Rules Committee to come to order, and thank you very much for coming back to Washington today in the midst of winter weather. I know that's plaguing all across the United States. Got up at 4 o'clock, got on a 6 o'clock flight, and it was pouring like crazy in Dallas, Texas. So, but I know that others that came later are behind, so I know that our committee is in the air as we speak, but we're going to move forward. Thank you, Mr. McGovern, for allowing us to do that. Today, the Rules Committee will consider H.R. 2406, the Sportsman's Heritage and Recreational Enhancement Act of 2015, and H.R. 3624, the Fraudulent Jointer Prevention Act of 2016. Outdoor sporting activities, including hunting and fishing and recreational shooting, are deeply ingrained in the fabric of our nation's culture and heritage. As an active Eagle Scout, I know firsthand the intrinsic value of our nation's public lands and the important role sportsmen play in their national stewardship. As an Eagle Scout, I visited all over this country, not only the great state of Colorado and New Mexico, but California and the beautiful parts of the Northeast. Part of the relationship that we have with public lands does include us passing on to our children and grandchildren hunting, fishing, and recreational sports. I want to thank the Sportsman's Caucus for moving this package here today. H.R. 2406 ensures that American sportsmen, fishermen, and recreational shooters have an equal opportunity to enjoy our nation's vast public lands. And since lack of access is one of the key reasons why sportsmen and women may stop participating in traditional outdoor sporting activities, ensuring that the public has reliable access to federal lands is also a top priority and something you will see in the bill. This legislation eliminates regulatory impediments and safeguards against new regulations that would impede outdoor sporting while simultaneously protecting our Second Amendment rights. Rules Committee today will also consider legislation to provide a uniform approach to deciding fraudulent joiner. And every day, local business owners routinely have lawsuits filed against them based on claims that have no connection to as a means of forum shopping on the part of lawyers filing cases. This is a huge problem for small business that does not have an active legal staff. The Fraudulent Jointer Prevention Act keeps legal claims in federal court that properly belong there by allowing federal judges to decide whether a local party is truly a legitimate defendant and not put there solely to keep the case in a trial lawyer-friendly state court. It is harming small business. It is causing small businesses to have to not only spend excessive money protecting themselves in state courts, but it's also creating a national problem in our court system. And I'm delighted that Congressman Ken Buck is here to not only lead this discussion today, but also to recognize from a legal perspective and a small business perspective how important this bill is. I know we also have Congressman Cicilline, who is here to speak on behalf of the Democrats. I want to thank both of you for being with us today. And before we have you come to the witness table, I'd like to defer to the gentleman from Massachusetts for any opening statement he'd like to make. Gentleman's recognized.
Well, thank you, Mr. Chairman. And let me first of all express my awe and admiration to you for achieving the rank of Eagle Scout. I have been to many Eagle Scout ceremonies. I know how difficult it is to achieve that rank, and I never did. I was a Cub Scout for a half an hour, and then I accidentally broke Mrs. Kane's ashtray, and I was asked to leave. So that was the end of my scouting career. But in any event, but I do think it's quite an achievement to reach the rank of Eagle Scout. Let me just say that I'm opposed to both of these bills. H.R. 2406 has some parts of it that I think we all can agree on in a bipartisan way. But there are other parts, quite frankly, that many of us believe would undermine environmental laws such as the National Environmental Policy Act, the Wilderness Act, and the Endangered Species Act. And so what I think might have been a bipartisan bill has become somewhat controversial, especially for those of us who consider ourselves strong stewards of the environment. With regard to H.R. 3624, I would just say that I oppose that as well because I think the majority is once again attempting to tilt the civil justice system in favor of corporate defendants by making it increasingly difficult for plaintiffs to pursue state law claims in state courts. And we're going to have testimony here and hear everybody's opinions, but in any event, I won't take up any more time, and I yield back.
Thank you very much. I appreciate the gentleman. Just so we are aware of what we're attempting to do today, we will have 3624 as one set of witnesses and one rule, and we will have a second set of witnesses under 2406, which is the Sportsman's Caucus Bill, and a separate rule for that. So we'll be working off what will be two rules today in the committee, and thank you very much. I want to now welcome our witnesses. I show that our first witnesses are going to be representing 3624, the gentleman from Colorado, Mr. Buck. Mr. Buck, I'd like to welcome you. We're delighted that you're here. Ms. Cicilline, we're delighted that you're here. I know you're from the Foreign Affairs Committee. Is that Judiciary also? Judiciary, so you're the main representative from Judiciary, and I know you serve on Foreign Affairs here. And I want to welcome both of you. What we do up here is we ask that anything you have in writing without objection, we'll now allow you to put that in the record. We'd love to have you summarize. We're really interested in hearing why you're here, what this bill is about, and the essence about why it's important that the United States Congress and the American people focus on these activities, because we think that you've come up here with a strong message of something that is important for the American people to know why Congress is taking time to do this. And Mr. Buck, we're going to go to you first. The gentleman is now recognized.
Thank you, Mr. Chairman. I have a statement for the record. In summary, this bill gives the judiciary some uniformity in deciding when a defendant has been joined fraudulently. It sets a good faith intention standard for the judiciary to make that determination. The legislation was actually requested in a written opinion by a Fourth Circuit judge, and there have been other judges around the country that have applied the standard in a non-uniform way, and so this bill tries to give some guidance to the judiciary on exactly what Congress's intents are as it pertains to joinder.
Thank you very much. Ms. Cicilline, welcome. We're delighted that
Thank you,
you're here.
Mr. Chairman, and I too want to congratulate you on being an Eagle Scout. I exceeded Mr. McGovern. I was a Weeblo, but still very far from an Eagle Scout, and I know it's what it takes to become one, so congratulations. And I thank you for the opportunity to testify with respect to the Fraudulent Joinder Prevention Act of 2016. And as Mr. McGovern said, it's my view that this is just the latest attempt to tilt the playing field in favor of corporate defendants by making it harder for ordinary people to pursue justice. And frankly, H.R. 3624 is really a solution in search of a problem. Because under current law, a defendant may remove a case alleging solely state law claims to a federal court only if there is complete diversity of citizenship between all plaintiffs and all defendants, with one exception. And if the plaintiff adds an in-state defendant to the case for purposes of defeating diversity jurisdiction, this constitutes fraudulent joinder, and in such circumstance, the case may be removed to federal court. And in determining whether a joinder was fraudulent, the court is required to consider whether there was any reasonable basis for the claim against the in-state defendant. For the case to remain in federal court, the defendant must show that there was no possibility of recovery or no reasonable basis for adding the in-state defendant. This is a very high standard. It has guided federal courts for more than a century, and most importantly, it has functioned very well. But the legislation before this committee would replace this time-honored standard with a highly ambiguous one, because the measure would require a remand motion to be denied unless the court finds, among other things, that it is, quote, plausible to conclude that applicable state law would impose liability, end quote, on an in-state defendant, and that the plaintiff had a, quote, good faith intention to prosecute the action against each in-state defendant or to seek a judgment, and that there was, quote, no actual fraud in the pleading of jurisdictional facts. So 3624 would effectively overturn the local defendant exception, which prohibits removal to federal court, even if complete diversity of citizenship exists when the defendant is a citizen of the state where the suit was filed. Although the bill's proponents assert that this bill is needed because the fraudulent joinder doctrine has been articulated differently by different courts, these distinctions do not substantively matter, as all courts must consider whether there is some basis in law and fact for a plaintiff to pursue a claim against an in-state defendant. If there is, then the federal court must remand the case back to state court. The bill proposes a really radical change to long-standing jurisdictional practice, and I think, frankly, reveals the true purpose of this measure. And it's simply to stifle the ability of plaintiffs to have their choice of forum and possibly even their day in court. In addition to that, 3624 would sharply increase uncertainty, delay, and the cost of litigation for plaintiffs and further burden the federal court system. The bill effectively requires a court to engage in a substantial merits inquiry at the very beginning of a case in the consideration of a basic procedural motion without the benefit of any substantial discovery. And that is a very dangerous practice to establish, where this kind of determination would have to be made at this stage of the litigation. For example, the bill applies a vague, open-ended plausibility standard that will require substantial litigation and the corresponding development of a substantial body of case law to implement it. And this undoubtedly would create more uncertainty, greater costs, and more unnecessary complexity at the very beginning stages of litigation. In addition, the bill will require a court to engage in an inquiry as to the subjective good faith intention of the plaintiff in adding an in-state defendant to the case. As with the bill's plausibility standard, this new requirement is a significant departure from current fraudulent joinder law, which only requires a court to ask whether there's a reasonable basis for the plaintiff's claim against an in-state defendant. And finally, this bill represents a significant intrusion into state sovereignty and raises, I think, serious federalism concerns. State law matters should be decided by state courts, subject to certain limited exceptions as set forth in the Constitution. Removal of a state court case to federal court always implicates federalism concerns, which is why the federal courts generally disfavor federal jurisdiction and read removal statutes narrowly. However, H.R. 3624 ignores these federalism concerns by applying sweeping and ambiguous new standards to the determination of when a state court must be remanded to when a matter must be remanded to state court. The bill denies state courts the ability to decide and ultimately shape state law. So I think this bill raises very serious state sovereignty questions, and our fundamental constitutional structure is, I think, questioned. And for all of those reasons, a very broad spectrum of consumer and public interest groups oppose this bill, including the Alliance for Justice, the Consumer Federation of America, the Center for Justice and Democracy, the National Consumer Law Center, the National Disability Rights Network, the National Employment Lawyers Association, and Public Citizen. So I urge members of this committee respectfully to oppose this highly problematic bill, which will ultimately result in many, many Americans being denied access to justice in our state courts. And I'm happy to answer any questions.
Thank you very much. I appreciate that. And I was unexpectedly thrust into this position. I feel, having listened to the early thing, I too have to confess, Mr. McGovern, I was a failed Cub Scout as well. But I have a son who is an Eagle Scout, so he followed, fortunately, the example of our chairman, not me. I just want to ask one question to Mr. Buck, and then obviously Mr. Sisling cares to weigh in. That'd certainly be appropriate. But could you give us some specific examples of the problems that your legislation would take care of, that you've run across, where we've had it sounds like basically a jury or court shopping, if you will, and how this would rectify that? Sure. In the case where a defendant wants to be in state court and not in federal court, that defendant can add a
a defendant to the case and require that case to be heard there. I don't have a specific case number for you, but that is the concept that this bill is trying to avoid.
And do you think that's a fairly common occurrence?
It's common enough that judiciary has mentioned it in a number of lower court decisions as well as circuit court decisions.
Mr. Sling, that, again, I think we all have at least heard of some instances like this, and the fact that we have judges bringing it to our attention does cause considerable concern. So I want to give you an opportunity to respond as to how frequent you see this.
Well, I think the important thing is that the current practice, which has been in place for over a century, is designed so that state court claims stay in state court, because state courts are best prepared to litigate and hear those claims, because that is the best opportunity for plaintiffs to have their cases heard under state law. And this is a narrow exception that allows removal of federal court because of all of the concerns about federalism and about state sovereignty and about whether we want federal courts litigating substantive state claims. So there's a narrow opportunity to do that. I think it has worked well. There's no evidence that it has not worked well. There's been no sort of analysis or study that I'm aware of that anyone has claimed that the current practice in place for over a century is not working. And in fact, the Supreme Court has specifically not taken a case where this question's been raised to sort of solve the kind of discrepancies in circuits. So I think it's frankly a piece of legislation which is a solution in search of a problem. This is a system that works. It works well. It, I think, properly, narrowly construes those cases in which that can probably remove to federal court, because the federal court is not equipped to hear state court claims. That's not its function. And I think most people recognize the different role the federal courts plays, and they want state courts deciding to state claims. And I think whether it's the intended consequence or an unintended consequence, it will substantially tilt the system in favor of corporate defendants because of the resources they will have to litigate in federal court that the average American just won't have. And that's why I'm here to oppose the legislation.
Thank you. Mr. Woodall? My friend, Mr. McGovern?
I have no questions other than I'd like to ask unanimous consent to insert in the record the dissenting views from the Judiciary Committee, which I think pretty succinctly kind of outlined some of the concerns that Mr. Cicilline has raised and that I expressed in the opening here. So if I could ask unanimous consent.
Without objection.
And I think I'm handling this tomorrow, right? Yeah, so
You'll have an
I will
opportunity
save
to
all
say.
my great rhetoric for tomorrow. Thank you.
Thank you. Mr. Burgess? Mr. Collins?
Well, I thank both my colleagues in the Judicial Committee for being here on this very eye-opening topic, and it'll be something Mr. McGovern and I will have the ability to talk about at length tomorrow.
I'm so lucky.
Yes, that I know.
Okay. Well, gentlemen, do you have anything to add? Or okay. Well, thank you very much for a very succinct presentation. Okay. If we could have our next panel that's here to deal with H.R. 2406. I think I saw Mr. Whitman come in. And Ms. Dingle's here. Welcome. Our chairman would be the first to say, if you brought anything in writing for the record, please make sure that our awesome stenographer gets a copy of that.
We will do that.
We would invite you to offer whatever summaries that you care to, and then obviously we'll move next to questions. So let's start with you, Mr. Whitman, if we may.
Well, thank you, Mr. Chairman. I appreciate the opportunity to bring before you the Sportsman's Caucus bill, the Sportsman's Heritage and Recreation Enhancement Act, better known as the SHARE Act. It is co-sponsored by Representative Tim Waltz, Representative Jeff Duncan, and Representative Gene Green. So it is indeed a bipartisan bill. It's a bill that is in the interest of hunters and sportsmen around the nation to make sure that they continue to have access to public lands, that we clarify what that access is. Those dollars, in many instances, were contributed by sportsmen for those access issues. So this actually clarifies that to make sure that indeed the intent of access on those lands keeps in mind the predominant use of sportsmen, particularly hunters and fishermen. It's a bill that's supported by our leading conservation and hunting and fishing groups around the nation, so it has broad bipartisan support across a variety of different individuals and organizations. And those organizations represent millions of outdoorsmen, so we think it's a common sense proposal. It expands those opportunities for folks that want to hunt and fish, which today is a significant issue as we have population centers that continue to push out and people want to enjoy the outdoors. Making sure that public lands are indeed available for that, we think, is extraordinarily important. And this bill will expand access, especially by requiring the Bureau of Land Management and U.S. Forest Service to keep those lands open for hunting. In some instances, they've restricted access. And the bill also requires the National Park Service or the Office of National Marine Sanctuaries to consult with local fish and wildlife agencies before they place restrictions on usage of these areas that indeed belong to the public. We want to make sure that as the states look at how they manage access, that the federal government consults with them. We think that's just common sense. We also want to make sure, too, we're protecting Second Amendment rights. As you know, Congress clarified the ability for sportsmen to bring their firearms onto national park lands. It did not cover lands managed by the Corps of Engineers. This clarifies that. Instead, it also includes lands that are adjudicated by the Corps of Engineers. It also prevents, on the side of the shooting sports, it also prevents EPA from unnecessarily regulating fishing and hunting products, specifically those made out of lead, whether they're fishing sinkers, whether they're bullets, ammunition, whatever it may be. We all know that the issues with lead are not ones that are specific to these devices being used. If they ban those, it creates a tremendous burden on sportsmen. In many instances, there aren't realistic or affordable alternatives. So we're just asking that through this legislation that the EPA be reasonable in how they put those issues forward. And you know, I'm an avid outdoorsman myself, love hunting and fishing, and I think all of these elements of this bill are common sense pieces of legislation going forward to really clarify things that need to happen that protect the interests of sportsmen. So I would request that the Rules Committee apply a structured rule for floor consideration of the SHARE Act. And in addition, I've offered a manager's amendment which makes technical changes, removes a provision that was signed into law since the SHARE Act was introduced, amends the Federal Lands Transaction Facilitation Act so that expenditures are subject to appropriations, and adds important language that improves Equal Access to Justice Act. And I respectfully ask that this manager's amendment be made in order.
Thank you. Now, turn, if we could, to my friend from Michigan, the gentlelady, Ms. Dingell.
Thank you, Mr. Chairman, and for the opportunity to testify with you all today. I'm here today on behalf of the minority of the Natural Resources Committee to testify in opposition to H.R. 246, the SHARE Act. It's disappointing to have to take this position today because I think this is really an opportunity for bipartisan legislation that would benefit the American people, and I still would like to see us try to get to that point. My home state of Michigan is a place where hunting and fishing is a way of life, and I think most of you know I'm married to a man who's probably more into hunting than most of the Republicans in this Congress. In Michigan, we're lucky to be surrounded by the natural beauty and bountiful wildlife, and some of the most enthusiastic hunters and anglers I know are also ardent conservationists. I was, again, married to one of them that wrote most of the conservation legislation that's currently on the books. Promoting conservation is not only the right thing to do, but it makes good economic sense as well. Nationally, the outdoor recreation economy generates $646 billion in consumer spending, which supports 6.1 million jobs. But if we want to ensure that opportunities for hunting and fishing remain available for future generations to enjoy, then we have to take the steps we need to conserve the places where the animals live. We can take steps to promote access to hunting, fishing, and other recreational activities without blowing huge holes in the Endangered Species Act, the National Environmental Policy Act, and other landmark conservation laws. And there are several concerning provisions in H.R. 2406. Title VI would block public participation in major land use decisions at national wildlife refuges. Title 13 would allow motorized vehicles in wilderness areas without any consideration whether their use would have a negative impact on the environment. And Title 10 would facilitate the slaughter of elephants in Africa. Unfortunately, the SHARE Act also admits several top priorities for hunters, anglers, and other outdoor enthusiasts. The North American Wetlands Conservation Act expired in 2012, and this bill has no new authorization for this critical law. And almost every hunter I know supports it and sees a need for it. I've offered an amendment to include the program in the bill, and I hope the committee will make it in order. The Partners for Fish and Wildlife Program, the Neotropical Migratory Bird Conservation Act, and the Multinational Species Conservation Funds are also conspicuously absent from this sportsman's package. And perhaps most notably, and I will admit one that I care the most about, is there is no long-term reauthorization of the Land and Water Conservation Fund, which has benefited every county in this country. As I said earlier, this bill really represents a missed opportunity to come together and negotiate a compromise bill that could pass the House using expedited procedures. We all want to support our hunters, anglers, and sportsmen. We just need to find the political courage to set aside the poison pill provisions so that we can get a bill the community deserves. We shouldn't let politics prevent us from reauthorizing these important programs that do so much good. So yes, while you hear about letters of support for this bill, I know that hunters and anglers throughout the country are thoroughly unimpressed. They don't want to undermine conservation laws that improve wildlife habitat. They don't care if they can take their guns to Army Corps of Engineer facilities where there's nothing to hunt. And certainly, they're not interested in supporting crime syndicates and terrorists that benefit from ivory trafficking. But those are things that will happen if this bill becomes law. Meanwhile, we'll miss out on important opportunities to make hunting, fishing, hiking, paddling, and wildlife watching better for our future generations. This committee has a chance to improve the bill. There are dozens of good amendments that have been filed to address these critical priorities, and I would urge the committee to make them all in order so we could have a good, healthy consideration on the floor. And our opinion of the minority, this H.R. 2406 does a disservice to folks who want nothing more than good opportunities to experience America's great outdoors. They deserve better, and I hope we can come together on a bipartisan compromise.
Thank you. Let me just ask a quick question, because frankly, I've had the opportunity to look at the legislation and have received a lot of support for it, frankly, from my district. I'm going to disagree with my friend from Michigan in one regard. I actually have Corps of Engineer land that would be great hunting land that people are just not allowed to access, and not even allowed to access it in ways that traditionally they have, and the Corps will come in after the fact and exercise jurisdiction. So whether this is the right language or not, I think we can debate, but I think it does address a real problem. You know, I am surprised, because I know both of you to be, you know, very ardent enthusiasts in terms of hunting and outdoor sportsmanship. So I'm a little puzzled they're on different sides. I wish we could find more common ground. Maybe we can in the amendment process. We'll wait and see about that. But Mr. Whitman, you know, obviously you've got a lot of Democratic and Republican support from people that we don't often see together. Mm-hmm. I want to give you an opportunity to address any of Ms. Dingell's comments that you care to, and then I'll obviously give her an opportunity to respond. I want to hear a little bit more of the debate, to be frank with you.
Sure. Well, as we've worked through this bill, we've talked to folks in every sector of the outdoor sports, hunters, fishermen, organizations that represent them, to try to find that area to where there's a balance between their efforts to make sure that they have access, that the agencies that are in charge of managing the lands and the resources keep in mind the main users of that land, and make sure that there is a reasonable process to make sure that access is assured. That's what I believe these bills achieve. And we've done that, again, by reaching across a variety of different sectors. I mean, these are organizations like the Coastal Conservation Association, the Safari International Club, all of those that look at this, and they really look at making sure that we are making the right policy decisions and making sure that there's a balance between the folks that are the owners of these public pieces of property and the agencies that are set with the direction on managing those properties. That's what these bills do, is to make sure that we have that proper balance there, to make sure that sportsmen have their say in how decisions are made on these pieces of property. We all believe that that's very thoughtful, very reasonable, and folks on both sides of the aisle, as well as millions of outdoorsmen, either represented by these organizations or individually, have said, please make these changes to make sure we can have these reasonable revisions to the law represented in the SHARE Act. Let me speak a little bit about elephant ivory. We talk about making sure that we are stopping the poaching of elephants, and I can tell you that we are all fully in favor of that. But what this provision does in the way the ban on ivory trade is to be instituted would then make it illegal for a grandmother that happens to have a family heirloom in her house that has some ivory in it from giving that to a family member. I mean, that's not what the purpose of this is. Also, many African nations are managing their elephant herds by controlled harvest. So what do? Hunters pay a significant amount of money to go there to harvest those elements. It's done legally. And for them to be able to import that ivory back in the United States has nothing to do with poaching, is actually a sustainable part of maintaining those elephant populations. If we stop that and we stop now the hunters that will go because they can't bring the ivory back, then are we really doing the right thing for those elephant herds? Are we really creating a sustainable economy there? Because if we take that economy away, what's going to take its place? Poaching will take its place. So to do this within a legal framework to make sure that folks can continue to harvest these elements, bring the ivory back legally, to make sure two people that have ivory already, that legally have that ivory, are now going to be restricted from being able to move that ivory anywhere. In fact, if you take the law to its extreme, they could actually be found in violation of possessing that ivory if they don't have something that they can clearly demonstrate that they prior to the law have purchased it or owned it prior to that. And for many folks, they don't. It's a family heirloom. So where do you go back and say, oh, I can prove that I own this prior to the ban on the sale of ivory? So I think there are many things that are problematic. Our bill seeks to clarify those things to make sure that people that have ivory today can continue to legally possess it, and that those that legally harvest elephants as part of a managed effort in those African nations can actually bring that ivory back. So those are my thoughts about some of the objections to
I think you
legislation.
do make a very good point on the ivory. I've never hunted elephants, but I have friends that have. And that's one of the first things they'll tell you is, number one, it's a pretty expensive enterprise
Yes.
to engage in. Number two, how much the local communities literally depend on it. If they don't have that business, you will see more poaching and a much more rapid decline in those kinds of areas of the population. So it's a concern. I want to give my friend from Michigan, obviously, an opportunity to respond to anything she cares to.
Well, I do want to respond on the ivory, because I actually received a call from the head of the, Ron Kagan, who's CEO of the Detroit Zoo, who feels very emotional on this. And he said to me that the poaching of elephants in Africa continues to be a crisis, that between 2010 and 2012, 100,000 elephants were illegally killed for their ivory, which is one every 15 minutes. And with all due respect, and we do agree on so much of this, it's really what's missing in this bill that if we could even get some of the amendments made in order, we could make this bill better. But staying on the ivory, what the Fish and Wildlife Service proposed new regulations that would require the sellers of ivory to demonstrate that their items qualify for exemption, and that they do have in that rule a de minimis rule, so that if it has under 200 grams, so if that family member that had the ivory piece, they would be exempt. And so that they tried to take that into account. And my problem with the way that this is written in the bill is that it would not allow the secretary to make any finding that this has been illegally traded. And it is a crisis still. I mean, we do need to worry about it. As I did say, what I'm very worried about is what's not in this bill. The Land and Water Conservation Fund, which I have to admit is one of the bills that I feel the most passionately about. We need to renew for the longer term. That's not done in here. I've talked to quietly all of our friends who are very concerned that the North American Wetlands Conservation Act is not included. That's what my amendment would actually address. And that's critical to many of to these wetlands across the country. So I'm as concerned about what's not in there as well as the ivory provision.
One last question to you both. I've received quite a bit of contact in my office from different sporting groups and that are in favor Are you aware of anybody that's opposed that's a sporting group?
Mr. Chairman, we haven't heard of anyone. In fact, if you look at some of the reasons why we didn't include some of these other larger bills in the context of their provisions in critical nature of what it means to sportsmen, like the Land and Water Conservation Fund, like the North American Wetlands Conservation Act, is those are major pieces of legislation and reauthorization that I think deserve their own time to be debated, to make sure we get those right, instead of clumping them all into a giant piece of legislation. And that's what people outside of here get mad at. I said, how do you put all these different pieces together? And I think we're both as passionate about getting those passed, but let's make sure we have the proper debate to do that. So it's not, I think, a reflection of any opposition to that. It's making sure that we do that in the right way, since these are major pieces of legislation. And if we want to do that in the right way and get it right over the long term, to take those up individually. And I can tell you, I'm as committed as anybody else in the committee to make sure that those bills do get taken up individually. But we haven't heard of any opposition from any of the outside groups, I've heard from a few individuals that have had issues, but haven't been opposed to the overall bill, have had some comments on the provisions in the bill.
So if we might, we can provide the committee with a list of 100 conservation groups that are opposed to this, including the League of Conservation Voters, the Wildlife Conservation Society, and a number of other groups that we both respect. And I would say that I agree with it. We need to be given consideration, but this bill is a very good vehicle. And if you just take the the Northlands bill, it expired 2 years ago. We knew these bills that are really critical for preserving our wildlife space. So that's why I'm pushing so hard for it. And it shouldn't have been so hard to have had the Land and Water Conservation Act renewed. And as you know, it too expired. We renewed it for 3 years in the omnibus, but it's a bill how many bills do you know that touch every county in the country, and all of the communities are benefiting for it, and people on both sides support?
Well, thank you both for your testimony. Mr. Woodall?
Thank you, Mr. Chairman. I just want to thank Mr. Whitman for bringing the bill. I tell folks all the time back home, I don't know when Republicans got a bad rap on the environment. Nobody plays outside in it more than we do. I know our Democratic friends play outside in it a great deal too, but I promise you no one cares more about wetlands in the state of Georgia than I do. No one cares more about the Land and Water Conservation Fund in Georgia than our constituents do. I appreciate your commitment to say you want to get all of these things done, but you have built a bipartisan team to bring this bill through today, and I don't regret that your bill is here. I regret that there are not more bills like your bill coming through this committee, and I just want to tell you publicly how much I appreciate that leadership, and how much I hope you as mentoring some of the others of us here, and we will repeat that process as we go forward.
Very good.
There. Thank you, Mr. Chairman. I yield back.
Okay. Our distinguished ranking members here. So.
Thank you, Mr. Cole. Thank you very much. Thank you both. It's good to have you here this afternoon, but I can't stand this bill. I don't know why we're doing. Do we have any idea when we're going to do a budget? Is that on any schedule forthcoming here?
I can't speak to it officially, but we are working it, and I suspect it'll get here probably sooner than budgets have in the past. We'll actually produce one, which my friends the last time they were in the majority didn't manage to do. So
Let me tell you, I really have to say that we come in here week after week and we do bills that we know aren't going to go anywhere. We do bills that have been around since maybe the 5th century. I really would like it very much. I think any bill that really brings back trapping and encourages rich people to go kill elephants and polar bears. I don't know anything particularly good that's coming from that. I, too, come from a long line of hunters from eastern Kentucky. But there was always this sort of rule. We never talked about it. We just knew that's what it was. If you fished something and killed a critter, it was for dinner. Nobody ever shot or killed anything that was not edible. And I just find this idea of going out for trophies, for heads to put on the wall. People, God knows, polar bears, we're worried to death whether they're going to be able to last another year. That it's just, I must say, I just really am offended. I don't support the bill at all. And I'm sorry we're giving it house room here. And we don't have the administration statement, which is not that unusual. But I would assume that if this were to pass both houses, that the president would veto it. But that's just my assumption. I don't have any fact on that. Thank you very much for the time.
Thank you. Mr. Collins, any questions? Mr. McGovern?
No, I will associate myself with our ranking member. I think there are some things in this bill that we all can agree on, and there are some things that I would like to think we could agree on to add. I mean, the Land and Water Conservation Fund in particular is one of them. It's something I've fought for all my years in Congress here, and I've seen the benefits both in my urban areas, in my suburban areas, in the rural areas of my district. And but I think there are so many potential problems with this bill and undermining of important environmental legislation and animal protection legislation that I can't support this either. And I don't think it will see the light of day beyond voting in this House, but if we're going to go through these exercises, I guess we're going to go through them. So thank you both for being here, and I yield back my time.
I thank both of you for your testimony, and again, if you have any written comments you'd care to leave, I know that would help our stenographer a great deal.
We will do that. Thank you.
Thank you.
Thank you.
Excused, and if we could, I think Mr. Griffin from Virginia, Mr. Ribble from Wisconsin, and Mr. Garamendi from California all have either points they wish to make or amendments they wish to offer, so I'd invite you all to come forward. Yes. Oh, I'm sorry, Ms. Lummis. Yes, absolutely. I better not have missed anybody else out there. Well, if we can proceed, actually what we'll do is hear your testimony individually before we question anybody. So that way all of you can present whatever points you care to make. Again, if you have any written material for our stenographer, she would appreciate it greatly. And with that, Mr. Griffin, let me start with you.
Thank you, Mr. Chairman. I greatly appreciate it. This little amendment that I have would just make it clear, if you're following the federal law in transporting a firearm, whether you're flying or traveling by car, that you cannot be arrested under local or state law as long as you're following the federal law. We make it pretty clear. We do put into this that if a local or state government charges you and you successfully defend saying, wait a minute, I was following the federal law, that local or state government then is liable, depending if the court rules that that's the case, they're liable to pay your attorney's fees. Because one of the problems we found is that some jurisdictions do this. They have a negative opinion about guns being transported, even if it's being done lawfully. We have several examples, a number of examples. It's even become a little bit of a cottage industry in the New York area, where they arrest folks, they confiscate the gun, they bring the charges, attorneys come in, and they generally get it worked out at this point. But the case that really shocked my conscience was a gentleman was traveling. He has a layover in an airport. This one happened to be Newark. He is told, okay, you got to get your bags. We don't have a plane for you, because when he got there, his plane had already left. He's following the federal law. He goes, checks into a hotel. The next morning, he shows back up. He's arrested because he's taken his gun off the airplane. Likewise, we had a situation where a veteran a few years back was traveling through Washington, D.C., again, lawfully carrying his gun, in a non-passenger area of the car, or in a locked container, not the glove box or console, which is the federal law. He stops off to see his doctor at Walter Reed, and he gets arrested. No misconduct whatsoever. Now, if there's misconduct, obviously that's a whole different ballgame, and this amendment would not affect that. But that's simply what this amendment does, and I'd be happy to answer questions at the appropriate time.
Thank you very much. Mr. Reed. Mr. Ribble, excuse me.
That's right. Thank you, Mr. Chairman. My amendment is a relatively simple amendment. I think it may be the only actual bipartisan amendment offered for this bill. What my amendment would do is reinstate the U.S. Fish and Wildlife Service rules of 2011 that had allowed for gray wolves to be delisted from the endangered species list in the western Great Lakes states and Wyoming. Those Great Lakes states are Michigan, Minnesota, and Wisconsin, and Wyoming. If you go back to the 1970s or so, Mr. Chairman, gray wolves had dwindled in population down to 15 in the state of Wisconsin, my home state. The wolves were listed by U.S. Fish and Wildlife as an endangered species and were protected. They were also reintroduced into Wisconsin. In 2011, the U.S. Fish and Wildlife Service had determined that the gray wolves had recovered enough, the numbers were in the hundreds, and that they should be delisted. In fact, they were delisted. However, in 2014, by a federal court ruling in Michigan, they effectively overruled the Fish and Wildlife's decision and relisted the gray wolf. Now, interestingly enough, the members of Congress that represent these areas, Republican Dan Benishek, Democrat Ron Kind, Republican Sean Duffy, Democrat Rick Nolan, Republican Reed Ribble, who all have wolves in those congressional districts, are all sponsors of this legislation and this fix. If we allow the court to overturn the Fish and Wildlife Service, we put the Endangered Species Act in and of itself in great peril, because then there is no rule at all, that the court can just come in and change the law whenever they choose without regard to the science that has been applied by the Fish and Wildlife Service. This can crumble and break apart the Endangered Species Act in and of itself. And so either the Fish and Wildlife Service is the predominant science-making body or they're not. But given that law in this country determined that they're the ones in charge of this, that the court overstepped its bounds in this regard. I'm trying to fix that wrong. And I'm trying to do this in bipartisan fashion. All my amendment does is for those 3 states in Wyoming, it reinstates the Fish and Wildlife Service and the Endangered Species Act as the predominant governing body in relationship to wolves. If, in fact, the wolf population dwindles, this bill would not prevent Fish and Wildlife Service from relisting the wolves and protecting them once again. It just leaves them as the governing scientific body as the law requires. And with that, I offer this amendment.
Thank you very much. Mr. Garamendi.
Thank you, Mr. Chairman. This amendment replicates what exists in about 40 states. It creates a national heritage area in the Sacramento-San Joaquin Delta. I'll hand out maps, and you guys can pass them around. The Delta is the largest estuary in the west coast of the Western Hemisphere, has a long, long history dating back way before the gold rush in California. The amendment would replicate the language of most every other national heritage area. For example, Alabama, Muscle Shoals. I can go through all of your districts, actually, and see if you're in here, Mr. Chairman. But there are about 60
You better worry about the real chairman. I'm only a temporary one, so he's right back there. You might want to know if there's anything in Texas.
He's the tough one. I was hoping I could get to you.
Texans are tough.
In any case, that's what the amendment does. It would establish that we've been working this for the last 2 sessions, this being the 3rd session. We have strong support from all of the various organizations, and in fact, the state has a program underway that this would fit very nicely with the Delta Protection Commission. So it's all there. We know of no opposition to it. Landowners that want to opt out can opt out. There's no requirement that any landowner be affected by it. But it does give the communities the opportunity to come together, to do the planning necessary, and to gain federal assistance where and when possible, and where there's money. That's basically it. Very short, but very, very important for the area.
Thank you very much. Ms. Lummis, you're recognized for your amendment.
Well, thank you, Mr. Chairman. I would like to punctuate some of the remarks that were made by Mr. Whitman with regard to this bill and highlight some things that are in it, as well as support Mr. Ribble's effort with regard to the gray wolf. This bill compiles numerous bills that have passed the House before, and some that have not. I want to highlight a few of them. FLTFA reauthorization is something that former Congressman, now U.S. Senator Martin Heinrich, and I had been working on for years. It would allow for an opportunity to convert federal lands that are on the disposal list into cash that can be used to enhance federal lands that are not on the disposal list. I think this is a practical way during tough economic times to allow federal land management agencies who have lands on disposal lists the opportunity through this reauthorization to make responsible use of the lands and convert land that was set aside for disposal because it doesn't fit into the mission or the management capabilities of the federal agencies into cash, so they can use that cash to enhance hunter access, to enhance the enhancement of our facilities on public lands, so many of which are in need of some improvements. I also want to put in a plug for EJA, the Equal Access to Justice Act changes that are in this bill. That's an act that was originally created to allow individuals, small businesses, mom and pops, and veterans, Social Security recipients to be reimbursed for their attorney's fees and costs if they have to have one of those once-in-a-lifetime lawsuits against the federal government when they have been denied a benefit or a right to which they are legally entitled. Over the years, it had morphed, and the payment of attorney's fees and costs now is not transparent. So the purpose of this is just to allow for more transparency so we know where that money's going, so we know if the intent of the program is still being upheld. I also want to explain to people who are concerned that something like Land and Water Conservation Fund permanent reauthorization is not in this bill, and I can explain that. The Land and Water Conservation Fund authorization expired at the end of September of this past year. In the Natural Resources Committee, we were in the process of going through reauthorization. We had a working draft. We'd had a hearing on the working draft. And for those of us who want to see the original intent of the Land and Water Conservation Fund reinstated, it was important that we have this discussion and reauthorize it to pursue the original intent. Originally, the Land and Water Conservation Fund was designed to provide 60% of the money to stateside programs and 40% to federal land acquisition. Now we find that over the years since the act was created, only about 12.5% of that money is going to stateside programs. The rest is going to programs like federal land acquisition. So it's flipped on its head from the original formula that was approved by Democrats and Republicans in Congress and approved by the Ford administration. So in other words, there's been so much mission drift in the Land and Water Conservation Fund program that we wanted to use the reauthorization process as an opportunity to reinstate the original intent of the program. But before we could do that, the omnibus bill we passed last December short-circuited our ability to reinstate the original intent of the Land and Water Conservation Fund by funding and reauthorizing not through the standing committee process, the authorizing committee process, but through the appropriations process. That's why it's not included here. And I can assure you that it is the intent of the Natural Resources Committee to go through the process of reauthorization in the way that standing committees are set up to do. Finally, Mr. Chairman, I want to punctuate Mr. Ribble's concern about the gray wolf. Here we have, based on science, sound science, a federal agency, the U.S. Fish and Wildlife Service, which is responsible for implementation of the Endangered Species Act, making a scientific determination that the wolf has recovered in the western Great Lakes states and in Wyoming. And we had federal district courts decide that no, their judgment should be substituted for the judgment of a federal agency that has the scientific basis and knowledge for making such a determination. It is appropriate in an instance like this for Congress, through its legislative authority, to instate the rules that were created by the U.S. Fish and Wildlife Service and delist the gray wolf in those 4 states and allow the states to administer those programs. As Mr. Ribble said, those states, if for some reason the populations were to decline to dangerous levels, the population could be relisted. But until such time, let me explain to you what's happening with moose in Wyoming. Moose keep their babies, their calves, in swampy areas, and it makes them fodder for wolves. And the wolves come down, and several wolves will distract the mother, try to attack the mother, while other wolves kill the baby. And they are down there, and they're absolutely helpless. And there are so many more wolves than objectives and science tell us are appropriate to have an appropriate ecological balance with other species, that the moose babies are being wiped out. And it's true with elk as well. If you look at the Lolo herd in southern Montana, the elk babies are being wiped out. So you have a maturing female population that literally hits a wall. And when those maturing elk hit their maturity, fertile maturity, and no longer can have babies, there are no young females to replace them. And the same is true with baby moose. At this point, there are more moose now in the Wasatch Range in Utah than the traditional populations that have been in the greater Yellowstone area. Many more. And you can blame it on climate change, you can blame it on bark on trees. That same set of scenarios is true in Utah, as is the greater Yellowstone area. The only factor that is different is wolves. Wolves are responsible for the massive decline of the moose in this area, and it is the only place in the world that this type of moose is indigenous to. What this bill is not just reinstating the science as determined by the U.S. Fish and Wildlife Service. It is a Moose Protection and Conservation Act. If you could see the devastation that these wolves are doing to these moose and elk, it would break your heart. It is unconscionable that we are letting judges overrule science in a way that destroys these populations. So I strongly speak in favor of the Ribble Amendment with regard to wolves and speak in favor of the bill. Thank you, Mr. Chairman.
Thank you. Mr. Chairman, would you like to reclaim your chair?
I'll sit over here. Thank you very much. I'll let you continue.
Well, well, I feel like I'm, under your watchful eye, so I don't think I make too many mistakes, but thank you. I really don't have any particular questions. I think you all make very excellent points, and I look forward to listening to my colleagues' question. I want to particularly thank my friend from Wyoming, because I thought that was an awesome demonstration of a range of knowledge about the legislation and a welcome history lesson on the omnibus process and the things that can go awry in it. I say that as an appropriator who ends up dealing with a lot of things that we don't want to deal with when we get legislation like that. My friend's point, I know she's made it in our conference on several occasions, and it's a very important point to be made. With that, I just thank all of you for your testimony and the points that you had to make. I want to go first to my friend, Mr. Woodall. Okay. My friend, right? Mr. Collins? Mr. Paulus? Mr. Chairman?
Thank you very much, Mr. Chairman. I want to thank each of you for coming here today. The opportunity for us to more clearly understand not just the West, but actually the relationship between man and environment, man and animal. I'm sorry? Oh, between men and women. Between women and animals, between women and... I meant that in a larger context, not mankind. But I have spent a good bit of time in the West, in Oregon and Washington and Nevada, West Texas and Colorado, and some parts of California. And in fact, I believe that some sense of people who set a standard in working relationships back home need to make more decisions and less decisions need to be made by what we're doing up here. And I just so much appreciate and respect because we get this package every year. It gives us a discussion item every year. And I believe, really on a bipartisan basis, there is a huge understanding that the West is undergoing tremendous change between drought, between growth, between a number of factors. And I just respect you so much for taking time to come up here today, not just to discuss these issues, but really for the entire Congress, which is why we put this on the floor every year to discuss these issues of not only wilderness, but how women will interact with our environment, women will interact with our out of doors, and how we can, as a nation, move forward in a better way. And I really do appreciate each and every one of you. And I watch a lot of National Geographic Wild, and in fact have watched the gray wolf herds and how they hunt and how they communicate and how they do things. But they can, in their strength, take down any other animal that gets in their sight. And I think that some balance is necessary for us. And so Mrs. Lummis's arguments, which really is information, was most appreciated, and I want to thank you. Thank you, Mr. Chairman.
Well, before I dismiss the panel, I want to thank all four of you again, and four of our really most active legislators. But I particularly want to single out Mr. Ribble and Ms. Lummis, because you're sadly have made the decision to leave us, and yet here you are working away. So your constituents need to know they're getting more than their money's worth as you complete both of your distinguished tenures in the House. So it's just good to see you up here. I know we'll see you up here again before either of you leave, but thank all four of you for your testimony.
Thank you.
This closes the hearing portion for H.R. 3624 and H.R. 2406.
Thank you very much. As I announced up front, we would be offering two separate packages, two pieces each that would be have a rule attached to it, and that is what we will do now. And so it's obviously Tom Cole Day, the Chairman Tom Cole Day at the Rules Committee, and the Chairman would now be in receipt of a motion from the gentleman from the great state of Oklahoma.
Thank you, Mr. Chairman. Mr. Chairman, I move the committee grant H.R. 3624, the Fraudulent Joinder Prevention Act of 2015, a structured rule. The rule provides 1 hour of general debate, equally divided and controlled by the chair and the ranking minority member of the Committee on the Judiciary. The rule waives all points of order against consideration of the bill. The rule makes an order as original text for the purpose of amendment. The amendment in the nature of a substitute recommended by the Committee on the Judiciary, now printed in the bill, and provides that it shall be considered as read. The rule waives all points of order against the amendment in the nature of a substitute. The rule makes in order only those further amendments printed in the Rules Committee report. Each such amendment may be offered only in the order printed in the report, may be offered only by a member designated in the report, shall be considered as read, shall be debatable for the time specified in the report, equally divided and controlled by the proponent and an opponent, shall not be subject to amendment, and shall not be subject to a demand for division of the question. The rule waives all points of order against the amendments printed in the report. Finally, the rule provides one motion to recommit with or without instructions.
I want to thank the gentleman. You've now heard the motion from the gentleman from the Sooner State, Oklahoma. Is there amendment or discussion to that?
Yes, Mr. Chairman, I have an
Gentleman's
amendment to the rule. I move the committee grant H.R. 3624 an open rule so that all members have the opportunity to offer amendments to the bill on the floor. And I ask for a yes vote.
Thank you very much. Discussion, further discussion. Seeing none, the vote will now be on Slaughter amendment. Those in favor of Slaughter amendment signify by saying aye. Those opposed, no.
Roll
Those having
call,
no still
please.
want to ask for a roll call vote.
Ms. Fox. Ms. Fox? No. Mr. Cole? Mr. Cole, no. Mr. Woodall? Mr. Woodall, no. Mr. Burgess? Mr. Burgess, no. Mr. Stivers? Mr. Collins? Mr. Collins, no. Mr. Byrne? Mr. Newhouse? Ms. Slaughter?
Yes.
Ms. Slaughter, aye. Mr. McGovern?
Aye.
Mr. McGovern, aye. Mr. Hastings? Mr. Polis?
Aye.
Mr. Polis, aye. Mr. Chairman?
No.
Mr. Chairman, no.
Clerk will report the total.
3 yeas, 6 nays.
Motion is not agreed to, the amendment's not agreed to for a minute or discussion.
Mr. Chairman.
Yes,
At this
sir.
point, I'd just like to speak in favor of this rule going forward. The rule provides for consideration of bill in a structured process. It makes in order 2 amendments, 1 Republican manager's amendment, 1 Democratic amendment. This is a straightforward rule. I'd urge all members to support it.
Thank you very much. Appreciate the facts of the case here. The gentleman from Massachusetts, seek recognition. No. All right, we will now move to the motion. The motion that's been laid on the floor by the gentleman, Mr. Cole. Those in favor signify by saying aye. Aye. Those opposed, no.
No.
The ayes have it. The ayes have it. Accordingly,
Roll call, please.
gentlewoman asks for a roll call vote.
Ms. Fox? Aye. Ms. Fox? Aye. Mr. Cole? Mr. Cole, aye. Mr. Woodall? Mr. Woodall, aye. Mr. Burgess? Mr. Burgess, aye. Mr. Stivers? Mr. Collins? Mr. Collins, aye. Mr. Byrne? Mr. Newhouse? Mr. Newhouse, aye. Ms. Slaughter?
No.
Ms. Slaughter, no. Mr. McGovern?
No.
Mr. McGovern, no. Mr. Hastings? Mr. Polis?
No.
Mr. Polis, no. Mr. Chairman?
Aye.
Mr. Chairman, aye.
Clerk will report the total.
7 yeas, 3 nays.
The motion passes. Motion passes. Accordingly, the gentleman, Mr. Collins, will be handling this for Republicans.
Mr. McGovern?
Mr. McGovern for Democrats. Thank you very much. The chairman will now be in receipt of a motion for 2406, the SHARE Act.
Mr. Chairman, I move the committee grant H.R. 2406, the SHARE Act, a structured rule. The rule provides 1 hour general debate equally divided and controlled by the chair and ranking minority member of the Committee on Natural Resources. The rule waives all points of order against consideration of the bill. The rule makes an order as original text for the purpose of amendment. The amendment in the nature of a substitute recommended by the Committee on Natural Resources, now printed in the bill, and provides that it shall be considered as read. The rule waives all points of order against that amendment in the nature of a substitute. The rule makes in order only those further amendments printed in the Rules Committee report. Each such amendment may be offered only in the order printed in the report, may be offered only by a member designated in the report, shall be considered as read, shall be debatable for the time specified in the report, equally divided and controlled by the proponent and an opponent, shall not be subject to amendment, and shall not be subject to a demand for division of the question. The rule waives all points of order against the amendments printed in the report. Finally, the rule provides 1 motion to recommit with or without instructions.
Thank you very much. You've heard the motion from the gentlewoman from Grandfather Community, North Carolina. The chairman would now defer to the gentleman, Mr. Newhouse, for a discussion on the rule.
Thank you, Mr. Chairman. This rule provides for consideration of the bill under a structured process. It makes in order 17 amendments almost evenly divided between both Republican and Democratic sponsors. This is a straightforward rule, and I urge members to support it. And just for a note, we do not expect another meeting this week.
That is very good news. That's really good news. I would now open up the floor to any amendments therein. Gentlemen
Mr.
from
Chairman,
Massachusetts.
I have an amendment to the rule. I move the committee grant H.R. 2406 an open rule so that all members have the opportunity to offer amendments to the bill on the floor.
You've now heard the amendment. Further discussion. Those in favor of the amendment from the gentleman from Massachusetts signify by saying aye.
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 Those opposed, no.
No.
Noes have it, noes have it. Further, gentleman asks for a roll call vote.
Ms. Fox?
No.
Ms. Fox? No. Mr. Cole? Mr. Cole, no. Mr. Woodall? Mr. Woodall, no. Mr. Burgess? Mr. Burgess, no. Mr. Stivers? Mr. Collins? Mr. Collins, no. Mr. Byrne? Mr. Newhouse? Mr. Newhouse, no. Ms. Slaughter?
Aye.
Ms. Slaughter, aye. Mr. McGovern?
Aye.
Mr. McGovern, aye. Mr. Hastings? Mr. Polis?
Aye.
Mr. Polis, aye. Mr. Chairman?
No.
Mr. Chairman, no.
Clerk will report the total.
3 yeas, 7 nays.
The amendment's not agreed to. Not agreed to. For amendment or discussion, gentleman from Colorado is recognized.
Mr. Chairman, I have an amendment to the rule. I move the committee make an order and give the necessary waivers for the following amendments to H.R. 2406, number 19, offered by Representative Sanford, Grijalva, and myself, and number 22, offered by Representative Grijalva and myself. And if I may, Mr. Chairman, I apologize, my flight was late. I hope to testify on these amendments, but I'm certainly proud to co-sponsor Amendment 22. This would simply take the illegal trade in ivory provisions out of the bill. I see them as unrelated, and along with many of my colleagues have written letters and helped introduce bills, including the Global Anti-Poaching Act, which passed the House in 2015, and I think it's important we don't reverse these significant gains in preventing the illegal slaughter of elephants for ivory. I'm hopeful that this committee will agree and make that amendment in order. My amendment to the rule also would allow for Mr. Sanford's amendment to permanently reauthorize the Land and Water Conservation Fund. I did catch the tail end of Ms. Loomis arguing why that was not in the bill. I think we should leave that up to the members of the body to decide if we ought to include the reauthorization of the Land and Water Conservation Fund in the bill. I personally support that. It's very important to my district and state. I'm hopefully that the committee agrees to make that in order as well, and I yield back.
Thank you very much. Further discussion? Hearing none, the vote will now be on the Polson amendment. Those in favor signify by saying aye.
Aye.
Those opposed, no. No. Noes have it, noes have it.
Roll call.
Gentleman asks for a roll call vote.
Ms. Fox?
No.
Ms. Fox? No. Mr. Cole? Mr. Cole, no. Mr. Woodall? Mr. Woodall, no. Mr. Burgess? Mr. Burgess, no. Mr. Stivers? Mr. Stivers, no. Mr. Collins? Mr. Collins, no. Mr. Byrne? Mr. Newhouse?
No.
Mr. Newhouse, no. Ms. Slaughter?
Aye.
Ms. Slaughter, aye. Mr. McGovern? Mr. McGovern, aye. Mr. Hastings? Mr. Polis? Mr. Polis, aye. Mr. Chairman?
No.
Mr. Chairman, no.
Clerk will report the total.
3 yeas, 8 nays.
Amendment's not agreed to. Further amendment or discussion? Seeing none, the vote now be on the motion from the gentlewoman from North Carolina. Those in favor signify by saying aye.
Aye.
Those opposed, no.
No.
The ayes have it, the ayes have it.
Roll
And
call.
the gentlewoman asks for a roll call vote.
Ms. Fox?
Aye.
Ms. Fox, aye. Mr. Cole? Mr. Cole, aye. Mr. Woodall? Mr. Woodall, aye. Mr. Burgess? Mr. Burgess, aye. Mr. Stivers? Mr. Stivers, aye. Mr. Collins? Mr. Collins, aye. Mr. Byrne? Mr. Newhouse?
Aye.
Mr. Newhouse, aye. Ms. Slaughter?
No.
Ms. Slaughter, no. Mr. McGovern? No. Mr. McGovern, no. Mr. Hastings? Mr. Polis? No. Mr. Polis, no. Mr. Chairman?
Aye.
Mr. Chairman, aye.
Clerk will report the total.
8 yeas, 3 nays.
The motion is agreed to. Motion is agreed to. Accordingly, the gentleman from the state of Washington, Mr. Newhouse, will be handling this for Republicans,
And I will handle it.
and Mrs. Slaughter for Democrats. It's previously been discussed, but we do not anticipate another meeting of the Rules Committee this week. Today is Tuesday. We've given ourselves enough work for the week. I want to thank everybody for their attention coming back and getting this done. The committee has now completed its work. Thank you.